Hello, Colin Manning here again. In this video, we're going to look at chapters 1 and 2 of the GDPR. Chapter 2 is probably the most important chapter, and it sets out the basic principles for data protection. We're not going to look at every single article of the GDPR, and nor are we going to look at them in numerical order. So first, let's take a look at Chapter 1 and some of the general provisions in there. Article 2 talks about the material scope of the GDPR. And it says that this regulation applies to the processing of personal data, wholly or partly, by automated means, and to the processing other than by automated means of personal data, which form part of a filing system or are intended to form part of a filing system. This is significant because it means it's not possible to escape the provisions of the GDPR by doing the data processing manually on paper. So it doesn't just apply to computer systems. It applies to non-computer systems also. Now, manual data processing is, of course, actually quite rare, but this provision means that you can't use manual processing as an escape clause. The GDPR does not apply to what's called a household activity. So it turns out there was a case under the Data Protection Directive in which an unfortunate woman in Sweden got herself into trouble. And so there's an exemption from the GDPR for things you might be doing at home. So if you have a little address book at home in your house of your friends, that's not covered. There's also an exemption from the GDPR for authorities pursuing criminal activity or trying to prevent threats to public security. If criminals or terrorists could phone up the police and say, hey, please tell me everything you know about me. That would sort of make crime prevention difficult. If we look at GDPR Article 3, there's a very interesting provision on the territorial scope. So it's quite unusual for a country to pass laws that apply outside of the jurisdiction of that country. But the GDPR applies regardless of whether the processing takes place in the Union or not. So that's quite unusual. So the GDPR applies to the processing of personal data of data subjects who are in the Union. So if you're processing data on people who live in the EU, the GDPR applies to that processing, irrespective of where you are in the world. So this means you can't avoid the provisions of the GDPR by exporting your processing overseas, for example. This extraterritorial provision has led to what some people call the Brussels effect. So if you are a business outside of Europe, for example, and you are selling to customers in the EU, the GDPR applies to your data processing of those EU-based data subjects. It might actually be very difficult for you to have two different data processing regimes on the go in your business, like one for EU-based customers and one for other customers. So often it might be simpler just to have a single system that meets all of the requirements of the GDPR. This has led to the widespread adoption of GDPR principles outside of the EU also. A similar thing has happened in the United States, actually. It's generally accepted that in the US, data subjects have many fewer rights than they do in the EU. But California has introduced legislation to provide protections to residents of California. A business in the US that sells to customers in California, for example, might have to operate two independent systems, two independent data processing regimes, one for Californians and one for non-Californians, the expense and complexity of that might be such that it's actually better to just apply the higher standard to all of your customers and to all of your data processing. And so in the US, we are starting to see also a California effect, where the provisions under California law and the data protection that Californian residents enjoy is being applied more generally across all the other states. Now, there are a number of definitions of concepts that are used throughout the GDPR, and the first of those is personal data. So in Article 4.1, we find that personal data means any information relating to an identified or identifiable natural person. Now, a natural person is what we would consider an individual, a person. A legal person, on the other hand, is a company. So in law, we distinguish between a natural person and a legal person. Personal data is information about people. What's very interesting here and what's very far-sighted is that personal data isn't just information relating to identified natural persons, but also to identifiable natural persons. So the kinds of information to which the GDPR applies can actually change over time as technology makes people more identifiable. Consider, for example, many years ago when phone books were just on paper. If someone had your phone number, well, they could call you. So if you left your phone number with the dry cleaner, if it came to it, the dry cleaner could pick up the phone and call that number. But they couldn't necessarily tell who you were. And often in old cop shows, you see a reverse phone book where, a phone number is involved and the police have access to this unique phone book which is searchable by phone number. So you look up the phone number and you get the name. But if you didn't have one of those, it was quite difficult and very impractical to go through the phone book name by name by name to match a phone number to a person. So a person back then was not identifiable from the phone number necessarily. However, when phone books were digitized and you could get them in CD-ROMs and then you could get them online, having a phone number is now more or less the same as being able to identify the person. Each phone number, because of mobile phones as well, typically is associated with a single person. And it's not that difficult if you have the phone number to find the person. So with the same piece of information, in the past it wasn't possible to identify an individual, but now it is. So as technology evolves, the way we can see a piece of information can change. The article goes on to talk about an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So that's very broad, and it can also apply to online IDs or a person's ID number, and even location data is in there. If you have information about the person that is at a particular location at a particular time, that can be personal data about that person that could identify them. One of the people who is in my house every night is me, because I live there. People may be moving around during the day, but if a person is at the same location every night, it's very likely that they live there. So you can associate that location with an individual. So the definition of personal data is very broad, and it's also very flexible and very far-sighted. it allows for the possibility that in the future it may be possible to identify people in other ways, using one or more factors. So it's broad and expandable, which is really important. A key concept in the GDPR is that of the data controller, and we see this defined in Article 4.7. A controller is the company or the person or whatever that determines the purposes and means of the processing of the personal data. So the controller is the person in charge, the person that makes the decisions. And that person is quite distinct from the processor. So the processor may just be an IT company that is processing data on behalf of a controller, for example. So in Article 4.8, the processor means the natural or legal person, public authority, agency or other body that processes personal data on behalf of the controller. So the processor is somewhat like a subcontractor. But the controller is the person that makes the decisions, that determines the purposes and the means of the processing of the personal data. And the distinction between the controller and the processor is important. The definition of processing appears in Article 4.2. Processing means any operation or set of operations which is performed on personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use. Again, a fairly broad and fairly expandable definition of processing there. So if information on individuals that are in the EU are passing through your IT system, it's hard to see how you wouldn't be carrying out one of these activities here that constitutes processing. So among the key concepts in the GDPR is the distinction between the data controller and the data processor and the data subject. So a data processor processes data on data subjects on behalf of the data controller. So the data subject is a natural person, is a human. Maybe his name is Dan Murphy. And Dan Murphy's data might be processed by Tesco, the supermarket. So when Dan goes and hands over his loyalty card, Tesco might gather that information and do various things with it. Tesco might engage a company called, Data Megacorp or something to analyze or process that data. And so Data Megacorp would be the data processor. But it's Tesco is making the decision to collect that data, and it's instructing the data processor how to process that data. And so Tesco is the data controller. And interesting, as we'll see later in the GDPR, the buck stops with the data controller actually, not with the data processor. So if things go wrong, it's the data controller is on the hook. So Chapter 1 mostly deals with those definitions. Chapter 2 of the GDPR then deals with the basic principles. And I think it's fair to say that Chapter 2 is probably the most important chapter of the GDPR. And so we're going to go through the individual articles now of Chapter 2 and discuss what they are, what they mean, the implications of them, and in some cases, some of the issues surrounding them. So GDPR Article 5 states that personal data shall be processed lawfully, fairly, and in a transparent manner. That's the first thing. It must be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that's incompatible with those purposes. So you must specify why you're collecting it. It should be adequate, relevant, and limited to what's necessary in relation to the purposes for which it's processed. So if you're collecting data for particular purposes, you shouldn't collect more than is necessary for those purposes. And we can see whether you're doing that or not because you have to be explicit about what those purposes are. So we can measure what you're doing against what you're trying to do. In Article 5D, we see that it must be accurate and up to date, and every reasonable step must be taken to ensure that personal data are accurate. Article 5E states that it must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which it's being processed. So you may want to keep statistical data, for example, on your customers, on the products which are the most popular, on the average spend for a customer. All of that, for example, might be done without identifying the actual customers. We may be able to do all that processing in a way that doesn't actually identify people. Article 5F requires you to keep that data secure. And this is one of the areas where many businesses fall down. They do a good job of processing the data lawfully, but their security is lax. And so the data that they're processing on individuals gets released into the wild, and that can cause problems for those individuals. In GDPR Article 5.2, it notes that the controller shall be responsible for and able to demonstrate compliance with paragraph 1. That's what we've just seen. So it's not enough that you have to do all of those things that are in Article 5. You have to demonstrate that you're doing them. So that would require very specific documentation. And it's interesting to think about what kind of documentation might this require? What form would that take? It would have to address each of the specific items in Article 5.1. So it's interesting to think about the documentary requirements there. And these would have to be available for inspection. Now, the GDPR also drills down then into some of the individual elements of Article 5.1. So Article 5.1a states that personal data shall be processed lawfully. In Article 6, it sets out specifically what that means. What makes the data processing lawful? So there are a number of conditions which can make your data processing lawful. And if you meet any one of those conditions, it's lawful. Article 6.1 sets out those conditions. In 6.1a, we can see that the data subject has given consent for the processing of his personal data. So that's probably the most commonly used one. If a person consents to the data processing, well, there you go. That's enough. Your data processing is lawful. We'll see, however, of course, that the issue of consent requires a bit more thought also, and there's a bit more detail on that too. You can make the processing lawful if the processing is necessary for the performance of a contract to which the data subject is party. So Amazon has to process some of my data, and it's fair to say that I'm sure Amazon, being very careful, has asked for my consent to process that data. But apart from that, Amazon has to process data about me in order to perform the contract that we've entered into. If I've entered into a contract with Amazon for Amazon to sell me a book, well, Amazon needs to know where I live so it can post it. So all of the information that Amazon needs to perform that contract it has made with me, Amazon is allowed to process. Article 6.1c provides for the processing of personal data if there's some legal obligation to do so. So if some other law requires that happen, then that makes the processing lawful. Article 6.1d allows for the processing of personal data if the processing is necessary in order to protect the vital interests of the data subject, or indeed another person. An extreme scenario here might be if you end up in hospital and you're unable to give your consent and some of your personal data needs to be processed in order to save your life. Well, that's in your vital interests. And so the hospital may have some flexibility there. The processing of the data about you would be lawful because it's in your vital interests. If that's in the vital interest of some other person, that may also be lawful. This mechanism for making the processing lawful is a bit out there. It's a bit on the edges, but it's there. Another one that's a bit out there is that if the processing is necessary for the performance of a task carried out in the public interest. Now, public interest is a bit vague. It's a bit general. But, there may be scenarios in which that makes the processing lawful. So the last thing that might make the processing lawful is if the processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party. This is quite vague and quite general, but it is perfectly reasonable for Amazon to gather information about its customers so that it can better serve them, so that it can figure out the kinds of things they like to buy, so that it can manage its stock levels well. These might all be considered legitimate interests. It's a bit vague, but of course it has to be properly articulated by the business for it to be lawful. So while your legitimate interests may indeed make the processing lawful, you would need to put some work into articulating what information you're storing, why you're storing, and how it meets the conditions of Article 6.1f. Very importantly, Article 6.1f does not apply to public authorities. So the government can't actually use 6.1f. An educational institution like MTU cannot use Article 6.1f. So although legitimate interest is very broad and very sweeping, it's not actually open to public authorities to use that. And that's something that's often forgotten or neglected. Now, Article 6.2 drills down a little bit and specifies that member states can introduce more specific provisions if they want to clarify what's meant by points C and E of Article 6.1. C is the provision on the legal obligation of the controller, and E refers to the public interest. So member states, if they want, can leave those sections as they are, so to speak, or they can introduce more legislation that can be more specific. So Article 6.4 then talks about the processing of data when the controller doesn't have the consent of the data subject. So if some data was collected and then it's being processed for another purpose, the data controller must assess whether that other purpose is compatible. And there are a number of criteria then that are used to judge that, and they're set out in Article 6.4. So if you haven't got the consent of the data subject, the controller has to take into account a number of things. And these are specified in Article 6.4. So the link between the purposes for which the personal data have been collected and the purposes of the processing. So if you collected it for one reason and you're processing it for another, what's the connection between those? The context in which the data have been collected is significant. and in particular the relationship between the data subjects and the controller. So if the data subjects and the controller have no relationship whatsoever, well, that might be a bit of a stretch. Whereas if I'm a customer of a particular business, for example, well, there's a connection between us. Another thing that must be considered is whether the personal data is one of the special categories of personal data that are set out in Article 9. We'll look at that a bit later, but some kinds of data are special and are more sensitive than others, and so that has to be considered. The controller must also consider the possible consequences of the intended processing, and also what kind of safeguards then that are put in place. These might be technological, for example. Pseudo-anonymization is one of the safeguards that's mentioned in Article 6.4, and this is actually defined earlier in the GDPR in Article 4.5. Pseudo-anonymization is the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information. So, for example, if as a lecturer at MTU I was to store personal data about students, but only use their student numbers as an index into that, well, in the event of a security breach and that information being made available to the public, people couldn't identify the individual students without having access to the mapping of student numbers to names. This can be taken to a whole new level where people's identifying information is removed and replaced with a unique identifier, so that lots of different processing, like if a customer comes back again and again, for example, if you want to connect different parts of information to that individual, you can do that in a way that allows you to do all the processing you want without it ever being possible to connect that data to the actual individual. For people who know about hash functions, for example, you could take the person's identifier and hash that in such a way that you can always identify the information about that person if you need it, but if that escapes, people can't work back to the individual. So Article 6.1 states that you can make the processing lawful by getting the consent of the data subject. But what constitutes consent? Well, Article 4.11 defines consent of the data subject as meaning any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by clear affirmative action, signifies agreement to the processing of the personal data relating to him or her. So this packs in here now quite a lot, okay? So it must be freely given, specific, informed, unambiguous. You may be asked to demonstrate that the consent you got from the users was unambiguous. It must also be a clear affirmative action. So this business whereby you have in your terms and conditions, by using this website, you agree to blah, blah, blah. No. It must be a clear affirmative action where the data subject makes a specific choice and actually affirms that, usually by clicking on the box or clicking whatever. But it must be something that the data subject actually does. So GDPR Article 7 sets out the conditions for consent, and it's quite detailed. So where processing is based on consent, the controller shall be able to demonstrate that the data subject has consented. So there's a regulatory documentary requirement there already. It's not enough for you to say, well, when people use our site, we make them click this and this and this. You must be able to show that a specific individual consented. If the data subject's consent is given in the context of a written declaration, which also concerns other matters, so this is an important point, The request for consent shall be presented in a manner which is clearly distinguishable from the other matters. So let's say, for example, when you sign up to a service, a social network, for example, the social network may need your permission to process information about you in order to make the social network work properly. It may also want to collect other information for other purposes. And a distinction must be made between those distinct purposes. So must be clearly distinguishable from other matters, and in an intelligible and easily accessible form, using clear and plain language. Interestingly, any part of such a declaration which constitutes an infringement of this regulation shall not be binding. And if the written declaration by which you got consent isn't intelligible or isn't easily accessible, well, then it doesn't count, and your processing may not be lawful. If it's not in clear and plain language, then your processing may not be lawful. So, although consent is by far and above the main way in which data controllers make their data processing lawful, you do have to wonder how much of the consent is in clear and plain language. So there's a communication issue here which is really important and really significant. And if that communication doesn't occur properly, the entire data processing operation may be unlawful as a result. Article 7.3 makes it very clear that the consent for the processing can be withdrawn at any time. So when you're designing your systems for processing data, you have to account for the possibility that some of the data that you've stored and are processing may need to be later removed from the system. It's not enough to say, well, they consented and know it's in there, I can't take it out now. Well, you may have to. It must also be as easy to withdraw consent as it is to give it. So if someone can give consent to the data processing by just clicking a checkbox on a website and clicking OK, it's not acceptable then for the controller to say, if you want to withdraw your consent, well, you must send us a letter in triplicate on pink paper to this address. It's not even acceptable that it has to be, a letter posted. If you can give consent online in under a second, well, maybe you should be able to withdraw your consent in under a minute or two. Now, GDPR Article 7.4 raises an interesting issue. So, some services may need your consent to process data in order to do whatever it is they do. So, something like Facebook or Instagram, for example, they would obviously need to do some processing of data in order to let you do the things that Facebook, Instagram, and Twitter do. But it's fair to say, I think, that a company like Facebook also does some processing that's more than is necessary for you to do the kinds of things you would do on Facebook. And of course, they ask you for consent to do that processing, and people generally give that consent. However, a distinction must be made between the processing that is required in order to do whatever it is Facebook does, and the other processing that Facebook might do, for example, to profile people, to do things with advertising and stuff like that. And so this is what Article 7.4 deals with. And it's saying, when assessing whether consent is freely given, utmost account shall be taken of whether the performance of a contract, including the provision of a service, is conditional on consent to the processing of personal data that is not necessary for the performance of the contract. So by rights, Facebook should be saying, look, this is the data we need to process for you to use Facebook and to post your things to Facebook. We want the consent to do that. And then there's all this other processing that we're doing that isn't necessary for us to give you the things you need to do on Facebook, but it's how we make our money. We also want your consent for that. And a strict reading of Article 7.4 suggests that separate consent is required for those two kinds of data processing. I think it's arguable that Facebook doesn't break them out like that, and indeed maybe it should. So if you want to do processing that's not necessary for the performance of the contract that you're entering into, that consent can't be bundled up all together. And you can't kind of consent to everything all in one go, because then you're not freely consenting to the extra processing. So Article 7 does raise some interesting questions, about consent and informed consent and the conditions that must be met for the consent to be legitimate. I mean, how would you rate the terms and conditions of a lot of services that you sign up for? Apart from being really, really, really long, I mean, are they intelligible? Are they accessible? Are they clear? Plain? I'm not sure many of the terms and conditions that we've signed up to for the various services that we use would score highly on any of those rankings. But what Article 7.4 is saying is that if these criteria are not met, then the consent is not valid, and then the processing is not lawful. That's a big deal. And so the language that's being used can be the difference between the processing being lawful or not. Now, GDPR Article 8 relates to consent given by children, and it addresses the extent to which children can actually give consent. So, by default, the processing of the personal data of a child shall be lawful where the child is at least 16 years old. So if you're processing the data of a child, if that child is over 16, then that's okay. Where the child isn't 16, such processing shall be lawful only if and to the extent that the consent is given or authorized by the holder of parental responsibility. So basically, if you want to process the data of a child that is not 16 or over, you have to get the parents' permission. Interestingly, however, there is a provision that allows for member states to lower the age to 13 years. And the member state Ireland has lowered the age to 13 years. So while in some member states you have to be 16 in order to give consent to your data being processed, in Ireland you only have to be 13. It is interesting why we should have made such a choice, and it is debatable whether that was a good choice or not. The choice Ireland has made has had some far-reaching consequences, because it turns out that Facebook and Google are regulated out of Ireland. So it means then that throughout the EU, the age at which you can give consent to Facebook processing your data is in fact 13 years of age, and not 16 as it might otherwise have been. Article 8.2 then talks about things like age verification technology. That hasn't really been very successful, and so most service providers don't really want to go there, and they just say you have to be 13 or over to use our service, and if you're not, you can't use it. Article 8.3 talks about the fact that nothing in the GDPR affects the contract law of a member state as it relates to a child. This is important because, as it turns out, in most societies, children cannot generally enter into contracts. So if you enter into a contract for the sale of a bicycle or something with a child, and the child doesn't pay up, as a general rule, you can't enforce that contract because in most jurisdictions, children cannot enter into contracts. And Article 8.3 is just saying that whatever GDPR says, of course, this doesn't change the fact that children can't enter into contracts. Article 9 talks about special categories of data. And as a general rule, these special categories of data cannot be processed at all. So some categories of data are so personal and considered so private that as a general rule, there's no scenario in which their processing would be acceptable. So this includes personal data revealing the racial or ethnic origin of the data subject, political opinions, religious or philosophical beliefs, trade union membership, and then also genetic data or biometric data that could identify the person, health data, and data concerning the person's sex life or sexual orientation. So as a general rule, processing any of that is prohibited outright. There are some exceptions. For the special categories of data, you can process it if you get explicit consent to process it. But this is a scenario where the criteria for informed consent would be enforced quite rigorously. It would have to be very explicit consent. Also, employment and social security and social protection law might require that information to be processed. The vital interests of the data subject incapable of giving consent, that's a scenario where your health data might be processed. If you're found in a coma somewhere and they bring you into the hospital, they've no idea who you are, you're not able to give your consent, they can still process your data because that's in your vital interests. Again, that's an extreme example. You can have a foundation or association of non-profit organisations, so clubs, things like that. If the data subject has manifestly made public data relating to them, that would be a special category of data, then it's acceptable for that to be processed. So if you take someone like Senator David Norris, who was a lifelong campaigner for gay rights in Ireland, the fact that he is gay is not a secret. It's not private information anymore. He has manifestly made that information public. Article 9.2f relates to legal claims. So if there's a court case that may override that prohibition on the processing of data, there may be a substantial public interest, whatever that might be. That's quite vague. Things to do with preventative or occupational medicine. Public health is a very interesting one. This was probably quite far-sighted, perhaps even prescient. Issues surrounding public health have come up since the arrival of the coronavirus on the scene, and the framers of the GDPR had foreseen the possibility of some sort of public health crisis that might give rise to the need to override the protections for health information. So you could imagine a situation where data about a person's health status could be processed without their consent if there was an overriding public health concern. Public interest, scientific or historical research, that can fit in there too, depending on the circumstances. But again, you would want to do a very good job of articulating that before you relied on it. The prohibition on processing certain types of data has some interesting implications, and there's some interesting interactions between that and artificial intelligence. So it would be prohibited for you to store in your database the fact that someone was a Muslim, for example. So if you came by that information, even if how you would even collect it lawfully is an issue. But if you had that information and you were processing that information, that would be unlawful. There would be very constrained circumstances in which that might be lawful. However, the provisions in Article 9 might be undermined because big data and AI are able to predict things about people with a very high degree of accuracy. So if you had someone's shopping habits and their location information and some other metadata about them, for example, that had nothing to do with their religion, you might be able to, with a high degree of accuracy, speculate that someone was in fact a Muslim. And so that poses a problem, because it means that categories of data about people that cannot be lawfully stored could perhaps be generated on the fly or generated on demand. And also, there may be data that could be proxies for data that's not lawful to store that could be used in decision making. So if you have an algorithm and you're deciding whether to give life insurance to someone or a mortgage to someone, and if you wanted to discriminate against Muslims when doing that, for example, you might even be able to do that without ever actually specifically identifying that individual as a Muslim. There may be proxies for that you could use. So big data and AI do pose some difficulties for Article 9. And I think in the future it'll be interesting to see the extent to which the scope of Article 9 can be expanded to account for those kind of issues. We may see some of that in the future. GDPR Article 11 deals with the processing of information where you don't need to identify the individual. And so that can happen. So you may be able to get information about people and process it, but that information, while it relates to an individual, it's not possible to trace that data back to the individual to which it concerns. That's something that may happen, and Article 11 provides for that. If the purpose for which the data controller possesses personal data do not or do no longer require the identification of the data subject by the controller shall not be obliged to maintain, acquire or process additional information in order to identify the data subject for the sole purpose of complying with this regulation. So if you have information in your database that relates to individuals, but that information can't be traced back to the individual, it exempts you a bit from some of the requirements in the regulation. Furthermore, if it's no longer possible to identify the data subject, then the data controller is excused from some of the obligations that they may have under the regulation. So a data subject, for example, has the right to access the information that's stored about them. But if in your database that no longer connects to the individual, well, when that request comes in, you might have to do a lot of work, or may even be impossible to find the information that relates to that individual. GDPR Article 11 counts for that scenario and lets you off the hook to some extent. It does also illustrate the benefits of pseudo-anonymization, or of disconnecting your data that you might be using for statistical purposes from the individuals as early as you can, because it'll make your life easier and it'll make compliance simpler and cheaper if it can no longer be traced back to those individuals. Of course, it also protects those individuals and protects their data in the event that something goes wrong. So that's something that should be considered as well. Generally, because storage is so cheap, people like to collect and keep data as long as they can and as much as they can. But it may be worth actually looking at your data storage strategies and deciding that maybe you can do much of the stuff you want to do with the data without it ever being able to identify the individuals that it relates to. So that's something to consider. In summary then, GDPR Chapter 2 specifies that data processing is lawful only when certain conditions are met. And it's quite specific about what those conditions are, and it even drills down into the details of those conditions. Consent is by far the most common way to make processing lawful, but that consent must be informed. Where you're engaged in commerce, you may need to store data in order to execute the contract in which the data subject has entered, and that's fair enough too. But it's important to remember there are special categories of data that are just, for the most part, out of the question. So religion, sexual orientation, trade union membership, for example, is perhaps a strange one. That information cannot be processed except in very, very specific circumstances. But a wise and cautious data controller would probably avoid it altogether and just have nothing to do with it.